Record. Okay. Good evening, everyone. This is our enabling ordinance ad hoc. It's Monday, March 18th. Good evening to everyone. How's everyone doing?
Good. Thanks, Jesse.
All right.
Yeah, we're great. We're sorry this is your last one. I
This
don't
is,
even know how to process that.
I'm sorry to say it is my last one too. It is, that's why I wanted to hopefully talk about sort of where we go from here, especially with some impending personnel changes. That also may mean it's a bit of a shorter meeting, depending on what the ad hoc decides, or we can continue on with the work that is here. So first off, if you have not already heard the news, both Commissioner Ordaz, Vice Chair, and I are resigning from the commission. Mine is effective tomorrow. Commissioner Ordaz is effective until either the end of April or the selection panel replaces her. I believe that there's only one person who's on the wait list for
Yeah,
the commission,
yeah.
which means that I think that you'll have Commissioner Ordaz until the end of April, but only for commission meetings, and I'm not sure what else she's going to be doing, but not this particular ad hoc. I also am resigning. I was appointed to the bench in Contra Costa, so I will have to shut down everything that I do and have done as part of my attorney duties and volunteer activities due to judicial canons. And so I guess where that leaves us is whether this ad hoc can continue on with the current personnel or other commissioners need to be appointed to the ad hoc and how long it might take to do that and updating our timeline for that.
Yeah. Yeah.
And I guess,
So,
yep,
the,
Chair, why don't you take that
the,
part?
the, yeah, I have had a couple of conversations with Rakisha Heron, who is the new chair of the selection panel. And their preference, as is mine, is that we would elevate Ricardo because your position will be vacated like tomorrow. We can't do any more um, until April 30th or sooner when we're kind of in a strange place. The selection panel will be meeting on the 20th. And because we didn't have official formal resignation letters, we did not elevate anyone at the last meeting. So we have to wait until their next meeting, which will be in April, unless our quorum is adversely affected. Say if Angela leaves, we don't have if she's not in town, we have to have a quorum in Oakland in order to bring in another commissioner and from out of town. So, it's kind of iffy whether or not we'll have a quorum. Micah sent out a document today requesting to know who's going to be at the meeting on the 28th so that we don't have to cancel it and we can elevate Ricardo. And like you said, Jesse, there's only one person on the selection panel's list, and they would prefer to have more than one person to review and talk to. So they are now sending out requests for people to put in applications. I sent them an application of a person who, the Kaiser labor specialist who's retired, and he had sent his application to the mayor. I've also contacted the mayor and asked her to fill her vacancies. I don't know what she's going to do because she has two but one is, of course, for a retired judge. So we've got a little iffy stuff going on between now and the 28th or April 30th. So stay tuned. I'm so sorry you're going, Jesse, but congratulations on this milestone in your career. We will definitely miss you.
Thank you. Thank you. And I suppose that the logistical difficulties bring up a few questions. One of which is, well, does this ad hoc continue with you, Chair, as the one sort of running the meetings on its weekly basis? Should it take a beat? Should there be some background work?
Well, see,
For
that's the second thing. I met with the Chief of Staff for Councilmember Jenkins last Friday, and because Commissioner Corelli and I had met with her and with Kiera, who is Councilmember Cal, Chief of Staff, maybe a couple of months ago when we first learned that this work needed to be done by us. And she said that they need to send the edits to the union. The union may want a full meet and confer, maybe not. They may just want to meet and discuss some elements. So we don't know whether or not that will be a very short interaction with the union or a longer one. So we can't really afford to wait and stop this work. So it's going to be wonky. I'm going to see who can come on to the ad hoc. I certainly do not have the skills to update and move things around like Jesse does. I'll be honest with you. And I'm not sure anyone else on the commission is either. So between now and next Monday, we're going to figure out how we're going to go forward. But I appreciate, Jesse, that you are taking us to, the end of your tenure here, and which obviously underscores your dedication to this work. And the commission appreciates it. I'm sure this ad hoc committee appreciates it as well. So we'll just have to find out. We'll work it out.
That brings up a question about scheduling. Does it make sense to have this ad hoc meet next week or the following week after the 28th, considering the busy schedules of many of our participants here?
I think, like I said, Council Member Jenkins knows that we have 2 resignations. I haven't talked to Council Member Calb's Chief of Staff, but it's pretty much going to be public come tomorrow that we have 1 vacancy effective tomorrow and another one perhaps as long as April 30th. So I think they would be forgiving of us not having a meeting next week as we work this out. That's all I can say. We're kind of between a rock and a hard place. So next week, no, let's not meet next week. Let's run out the clock tonight and see how we can fix this going forward.
Sure. And then I see that at least on the state side, I think, if I am not wrong, Monday, April 1st is a state holiday. Is that a city holiday? Cesar
I thought
Chavez.
it was March 29th. Isn't it March 29th? That Friday is the day that the city recognizes Cesar Chavez Day.
Any city
Is it
employees that can
April 1st
eliminate
or is
us.
it
I think
March 29th? Hmm. So we'll have our meeting on the 28th and we won't, we, next Monday is not the, is the, what?
25th.
Let me get my cat. Yeah, so we will miss the 25th. And what do I have here for the 29th? March 29th.
I think the 29th
Oh,
is a
March 29th is Good Friday. I don't know what the city does with that. Monday, April 1st is just April Fool's Day. I'm not seeing Cesar Chavez. Anybody can confirm that Cesar Chavez is on the 29th as
Mac.
opposed to the what?
Cesar Chavez Day is on the 31st and falls for city employees on April 1st. Or is
Okay,
it,
so okay. All right. Maybe it's because the school is going to be out that day and all the following week. So I think that's just the way they captured their spring break. Okay.
And
So
that'll,
today's the 18th. We won't meet on the 25th. Obviously, then we won't meet on the 1st. That's a holiday as well, unless there's a strong desire to do so. I'd like to hear from the other members of the ad hoc.
Mac.
Hello.
I don't believe I can meet on the 1st on that evening. I may be
Okay.
in transit in a way that prevents me from communicating.
Okay.
Mr.
IG, are you
Nosh.
on the?
Yeah, I just think as soon as we can replace the outgoing commissioners, we should try to carry on expeditiously if we can.
Yes.
I don't know how long the city council is going to wait on this. It's been a minute. And it may be that we'll need to change the Monday evening to a different evening. Um,
You cut out, given.
yeah,
Not
I would
hearing.
just suggest that we not wait too long after we are able to replenish this ad hoc with some additional commissioners. It may
Okay,
mean that we have to move from Monday since it's a holiday, but I don't think we should wait 3 weeks. I think that
okay.
would be a bit too long.
And and on Tuesday, we have I think that's the,
Hmm. Why don't I recommend that, um, why don't I recommend that, chair, um, figure out how the incoming commissioners and then see what their availability is the week of the April 1st. And then send emails out to see if a meeting can be scheduled on that week on one of the other days. And if that doesn't work out, then just pick up on the following Monday, which is the 8th. I will, got it. I will Michelle, is that for the entire week of the 1st, or is that for the 1st?
No, it's for the entire week. I sent an email out. I am speaking on a panel at NFBPA for that week at a conference for uh, public safety through police accountability. So I won't be here, but I can ask Charlotte to come.
Thank you. Okay.
And that's from, just for FYI, that's from the 2nd through the 8th. I'll be flying on the 8th, so I won't be here if we do have a meeting on the 8th as well.
Okay. Noted. Thank you. Okay. Well, some challenges ahead, but we'll try to do as much work as we can in the meanwhile, and then make some contingency plans as well. Any other thoughts before we jump back into 2.45? Okay. Why don't we get started? I apologize. I know it's a little bit small. That's because I have a second screen going to remind myself about things. We left off in 2.45.070, and the last section that we discussed was section D. And it was a little bit of a longer discussion about section D. Let me just make sure. Yes, section D. And I think we stopped after section D. We did have a longer discussion about some of the aspects of section D, including discussions about structure, role, what should go in, what shouldn't. At least that's what I recall. I also recall that we don't yet have information from our heads about the possibility of budget priority presentations versus submissions of budget and the particular times. I think that's partly because we're currently in the middle of the budget cycle and budget season. So getting through that might help us get some clarity on what works and what doesn't work, as well as the uncertainty of when those documents come on an annual basis. So I think it makes sense to move on to section E, unless I've forgotten that we have talked about E. And I apologize if we have. Let's see. Sustain finding. Ms. Grenache?
Yes, we did talk about E. I raised the issue about having a parallel investigation, right? I think we
Yes.
had a fairly lengthy discussion about that.
Thank you for the reminder. You're right. Okay. Let's I guess that brings up a much larger question and structural question that we may not have answers for tonight, but perhaps we can try to focus on the ordinance that's in front of us or continue that discussion. Anyone have anything else to add or to say or to discuss in section E? I know I'm leaving open the very large discussion and the question that we have about this. What about section E? Commission Counsel?
that it's not necessary to say the word final, because the sustained finding is defined by law, by state law and court cases. So it is after administrative hearing rights. So saying final is redundant and may be confusing.
I couldn't really hear that remark. Could you repeat that a little bit more loudly?
Oh, sorry, Ms. Grenache. I can understand why people needed to add the word final to the word, to the quote unquote phrase sustained finding. But that sustained finding is found in state law. And it's defined by court cases, et cetera. So it's not necessary to say the word final. And we confuse the legal requirements to mean more than it already is, which is investigation, disciplinary records only after appeals hearing.
Ms. Grenache?
Yeah, I don't think the issue was the legal threshold for sustained finding. I think the issue was the manner in which the commission is able to determine a finding and whether it relies on a single outside investigation or whether the commission is able to determine a finding based on a comparison between an outside investigation and a commission directed investigation.
Mm. Okay, all right. With the CDC, let's look at Knox and Ross and CDC. Where do each of those fall? The Knox and Ross was the commission initiated investigation, and CDC was OCA initiated investigation. Am I right?
Yes,
Michelle?
you're right.
Michelle?
So the way I would read the scope, and I've read the scope of Knox and Ross, was that it was the review of documents. It was not an investigation.
Ah, okay.
It was a review of what had already been completed. It, in and of itself is not an investigation. So that's just a characterization of that particular, those particular.
Okay, so in this paragraph, are we making a somewhat of a nuanced, sort of distinction? Is there a different word that should be used?
I hear Ms. Grenache to be saying that the discussion that we previously had to go towards how the commission may make a decision about an investigation or a review or whatever it might be when it makes its sustained finding of misconduct against the chief. That was a very large discussion that we had I think it was 2 weeks ago, perhaps at this point, where we discussed sort of what that mechanism is, how the commission may do it, whether it might, whether the commission should be directing CPRA to conduct its own investigation. I think I take Commission Counsel's point to be on a slightly different point, which is that the question of final, that's in section 2, that's right there on the screen, kind of describes something more than is needed in law, that a sustained finding is a term of art that is well defined in both law and in case law, and that to add the word final is superfluous, at least for this particular paragraph. That particular point doesn't seem to resolve the issue of how the commission may make its decisions in this particular section. And of course, later on in the other section, which relates to the IG's good cause removal provisions. I think I take both points.
Mm.
But I think that's the discussion that's going on right now. And I do also remember
Okay.
that Director Muir mentioned that having the word final here may actually be more than what is intended. Discusses matters that may go above and beyond what may be the intent of this. Final means once all the appeals have run, all the Skelly hearings, all the
Right.
and to wait until that, I think potentially may hamstring us or may limit the power of the commission to remove the chief, at least under this particular ground.
Okay. Okay, so we're talking about removal of the chief. But what other example? I mean, I wasn't on the commission when Kirkpatrick was terminated. Was there an final investigation or an investigation and we took some action as a result? Is that what this, is this what this is talking about?
No, Kirkpatrick was not removed by the commission. Kirkpatrick was removed
Moved by
the
the
mayor,
mayor.
who did
But
not
we,
need to find cause.
oh, and we just joined in.
Correct.
That's what it-
Correct.
Yeah. Okay. All right. So what is this then? This, is it just a matter of the recommendation of council that we would just remove the word final, or we need to do some additional wordsmithing?
If final, not from a legal standpoint, but from everyone understanding that, that adds the layer of meaning to it to mean after, appeal rights, have been granted, then, and it, this came from the city, the word final.
Oh,
So,
that's interesting because they should know that
yeah,
final might
so,
entail all the different appeals.
yeah. Although in state law right now, it doesn't use the word final, it just says sustained finding, and that means after appeals hearing. So it's already embedded in that meaning. But
Okay.
I get what Ms. Granach was saying, that this speaks to not the state law of disclosure of information, but more of the commission taking on a for-cause firing of the chief. And so the word final has meaning in that context that is not in the state law context of public disclosure. So if that gives people comfort, then we can keep with final, especially since this came from the city too.
We should not add additional language that could create, especially in union arbitrations, some other connotation or meaning. Like, what does it mean when you say final? And what does it mean when if you added the word final, what did you mean by that? In as much as it's understood under state law what final means. Maybe creating
Yeah.
some ambiguity.
Yeah, this came from the city, so OCA presumably reviewed it too. So this gives people more comfort with the word final as it relates to the cause for firing of a chief. So we can go ahead and keep final. So chair, committee chair, I get to say that for last time probably. So you can go ahead and proceed.
Thank you.
Okay, are we are we going to delete the word final? Or are we going to keep the word final?
As
Go
of
ahead.
right now, I'm not going to delete it. I'll just make a note about it. And
Yeah,
then
make a
the
note, at least
future
yellow it out,
iterations,
yeah.
yep, we'll figure it out and come to a consensus about it.
Okay.
Any other comments, edits, additions, subtractions from this section, which discusses cause for removal of the chief by the commission?
Okay. Awesome commission. Nope.
Ms. Grenache?
I'm sorry. I feel like I'm beating a dead horse here, but I really feel this is a very important, perhaps the most important element of the ordinance. And I really think we have to get it right. We have to, if the commission has the authority to find cause, which is what is described in section E, we need a process by which it does so. And the only process that is named here doesn't even involve the commission. It involves the city hiring an outside investigator
Yeah.
to investigate allegations. That is the only process that is described here, and it is not a process of the commission.
Commission. So should we say an IAD investigation as well? Not an IAD, a CIPRA. A
I believe
parallel.
so.
Yeah,
I
a
believe so.
parallel.
It
Yeah.
may not have to be in this section. It should be in the 06 instead of 05. But somewhere in the ordinance, there needs to be a process that is described that allows the commission to be able to adjudicate and come to a finding based on not just one outside investigator that you haven't even chosen, that the
That's
city has
true.
chosen,
Yeah.
and you either take it or leave it,
Yeah.
and you have no basis upon which to take it or leave it, which is what
Yeah.
happened the last time.
CDC.
Why does it need to be
So
in, why does it need to be in the OMC as opposed to, say, some rules of procedure that might discuss how cause is determined?
I believe it needs to be elevated to the commission, frankly, to the ordinance. I don't think it's something that the commission should be able to change on its own without the authority of law, basically, which is what the ordinance is.
But I guess the question is why?
I guess to ensure that the commission is properly placed within the removal process of the chief, and it's not just ceded to the city to get their own investigator and take that investigator's report and recommendation without us having any bearing on it. Is that what you're
Exactly.
saying, Ms. Grenade?
Yes, exactly, because you have no independent way to determine whether or not you agree with the findings of that investigation, because you have nothing to compare it to.
Right.
Let me just
Well,
make
why
an
wouldn't we?
observation about that though,
Okay, go ahead.
because this is the, and then I'll actually should let IG Phillips talk, but if this is the section that authorizes the commission to determine that there's cause to fire the chief, doesn't it also give the commission the power to look at the finding and determine there isn't cause to fire the chief?
Based on what?
Yeah,
Because
that would be
because it's the
implied.
act. It's the act. This is essentially saying you want to fire the chief. One of these reasons can be cause, and in order to do so, you need 5 affirmative votes. And if you don't believe that there's cause, even with a sustained finding, you don't vote. You don't hit 5. You don't have
Well-
5 votes.
But it doesn't kind of say that. It kind of like gives all of that power to OCA, which may be the reason why they put it in there.
And part of what I'm saying is the commission has to make an affirmative act in order to make a finding of cause, and in order to fire the chief. And if the commission, after reviewing documents or investigations, decides that they don't want to do that, they just don't do it, right?
Do you see that in here or implied in here anywhere?
Yeah, because it's essentially the commission will have a vote. They'll review whatever documents that there are along one of these lines, and if they make a determination like, no, we don't want to remove the chief and we're not voting for it, there is not.
But if the mayor decides she wants to ask OCA to hire an outside firm like they did with the CDC, Armstrong, they made a finding of untruthfulness. Well, they were just going to discipline him, but at the end of the day, that became kind of the catalyst for why he should no longer hold the position, along with him mouthing off about the monitor. But that was all their process. That wasn't us.
There are lots of hands up.
And I guess
Miss Grenage, new hand, old hand.
I'm sorry. I'll lower my hand and I'll yield to the Commission Counsel and Director Muir.
Director Muir?
So, Commissioner, I do agree that the commission has to take an affirmative action. I understand the concern that this might be coming from one place, and that I don't think anything in this, for example, in the case of the outside investigation, I don't think the commission could have prevented a mayor from taking action, but the commission could have declined to take action based on the facts they were presented with, assuming they were presented with those in a timely fashion to review all the documents. One just point of information, and I do think some of this could go into the CPRA section of the ordinance. My understanding, and I would love to be corrected if I'm off here, is that the CDC investigation was done by an outside investigator, essentially in place of internal affairs, and that it was considered an internal complaint. And at the time that this took place, internal complaints were not sent to the CPRA. My understanding is that is no longer the case, and if it isn't happening already, certainly it's partially happening, that complaints internally, generally complaints are being sent to the CPRA. So this agency would have been aware of that process from its inception. And I see IG Phillips' hand, who was here during all that. Greatly appreciate your insight.
Absolutely, Chair, if I may. Director Muir is absolutely correct. It was an internally generated complaint, the first complaint, and then through a process, there was the second issue. So all of these were internal. To Director Muir's point, CPRA they were only getting complaints that were publicly generated. I think the last update to M3 provided that information is now going to change, and they will be getting all the complaints. And I can stand corrected, but that's the information I received from OPD. Additionally, because the outside firm stood in, they were standing in to ensure that there was no conflict or potential retaliation towards IAD officers because all of those individuals report up to the chief. Therefore, OPD was also removed from any discipline recommendations at that time as well. So even if this happened and there was a parallel investigation similar to what would happen with IAD and CPRA, kind of concurrent,
Right.
I would believe that the commission could vote one way or another, but the city administrator would still have the authority regardless to act, because with a sustained finding, there must be an action. Whether, the commission votes to not act, there still must be a something based on the sustained finding, and wherever that sustained finding or required or recommended discipline falls within the disciplinary metrics. So if the chief of police, if the person is the chief of police who is the subject, then the city administrator would have the opportunity to weigh in on the discipline, similar to the police commission would also be able to weigh in, and that was similar to the process previous. So hopefully that's helpful.
It does. Thank you, Director Muir.
All said, I think that with the understanding that there needs to be further conversation around potential parallel investigations, that
Mhm.
doesn't necessarily need to be done by limiting the commission's scope here. And just one might say any sustained finding of misconduct may allow the commission to consider removal, and that we can separately, whether it's through a procedure or an ordinance change, identify CPRA's role in that process. That would be my proposal.
Should we use the word may or shall?
Well, right now it says, actually it's a little higher up. It would be it would be previous to all this.
What are you
Shall is what it says. So if you scroll down,
Okay.
it says in addition to the powers and duties described in section 604, the commission shall, and then if you scroll down to E,
have the authority to remove
have
the
the
chief?
authority.
Okay.
So shall have the, sorry, Ms. Grenache.
Yeah, I just want to make a couple of points. First of all, the mayor, as I said before, the mayor does not need to find cause to remove the chief.
Correct.
The mayor can remove the chief for whatever reason, with or
Correct.
without the agreement of the commission. So
Correct.
I think we need to put that aside and then look at the authority of the commission, because that's what this ordinance is about, not about the mayor, and it's not about the city administrator. So this is about the authority that is given to the commission. It may very well be that an outside investigation exonerates the chief, but that doesn't mean the commission has to. The commission, if it had a parallel investigation done, might see it differently and might actually sustain and find cause, right? So we have to really be careful not to mix apples and oranges here. We're not looking at what the mayor may or may not do. We're looking at the authority that is given to the commission and the basis upon which the commission makes a determination either to sustain or not sustain. That's what we're looking at. Thank you.
And
I feel like that is dealt with by the power to direct CPRA to conduct an investigation. But the commission has that power, and it has it in other sections, and it has it in those sections which may relate to investigating certain misconduct. It feels like the answer to your question, Ms. Grenache, is about that power of the commission to direct said investigation and under which circumstances to do so.
I agree, Jesse, but I think that the language in 046 has to do with investigation of officers, not the chief. And so I think that it may require some additional language that makes it clear that the CPRA can be directed by the commission to investigate not only allegations of misconduct by officers, but also command staff and the chief.
Is there any other, well, is that just a blanket whenever the commission feels like it, or along certain lines, or along the lines that are listed in this section E?
Yeah, I think along the lines of the allegations that pertain to this section that would constitute cause.
Okay.
And remember, we kind of got bogged down in the chief's termination on whether or not we, as a commission, could convene a disciplinary committee, but SIPR hadn't done its own investigation. So I don't want to see us in that situation again.
IG Phillips?
So I just want to make sure that I'm clear. Are we saying that allegations of any of the below? So if we scroll down, gross neglect of duties, material violation of any duty of loyalty, like all of these allegations, inclusive of any allegation on the disciplinary metrics that could result in termination, should automatically trigger a CPRA investigation. Is that what we're saying?
I don't.
That's what I think.
I see. I had thought it was just a discretionary. The commission may choose to have CPRA conduct that investigation. Ms. Grenache clarified her position that it is, or it should be, an automatic. What that trigger is, Ms. Grenache, do you have a sense of what that trigger might be that would trigger said automatic investigation?
Any allegations that relate to the causes that are enumerated in section E, which would lead to termination if sustained, should trigger.
With that, IG Phillips, thoughts or reactions, and then Director Muir.
I'm going to yield to Director Muir, put my hand down, and I'm going to chomp on.
Director Muir.
Thank you. I just like to, even in section E4 here, where it says, let's talk about hypotheticals. Let's say that a chief of police enters a guilty plea in a court of competent and final jurisdiction for a crime of moral turpitude. My argument would be that a CPRA investigation is not necessary in every case for the commission to weigh whether that should be cause for removal, or refusal or failure to cooperate with an investigation. Perhaps it depends on the circumstances. Gross neglect of duties, right? Built into these is that there's already been a finding. And so I just wouldn't want to trigger an investigation into something where the facts have already been determined, and thus belabor a process where the commission may know enough to make a reasonable finding. It says a material act of fraud or embezzlement. Presumably, if that has occurred and there's evidence that that's occurred, the commission might want to weigh whether or not an investigation is the appropriate next step, as opposed to automatically triggering a CPRA investigation. I can see a vast number of circumstances in which a CPRA investigation would be appropriate. I would also say that one of the central challenges, it seems here, is the concern that CPRA would not even become aware of the opportunity to conduct an investigation.
Right.
And my hope would be, at the end result of this process, we certainly have an obligation, whether that's for the city attorney's office or for any city employee, to make this agency aware of such allegations so that we aren't ever left in the dust. But I think that any of these categories automatically triggering a CPRA investigation shouldn't be quite it. I think that we could have a separate category that says, should X, Y, or Z be alleged, perhaps the CPRA would automatically conduct an investigation. But I don't necessarily think it falls within this section E.
IG Phillips.
I'll go ahead and let the chair speak, if that's okay, Chair. The other chair.
Not chair much longer. Chair Peterson.
Well, this has to do with criminality, conviction by or entry of plea of guilty or no in a for the content of final jurisdiction. Yeah, well, felony offense, these are all crimes. And I guess that is really not something that we would be able to adjudicate even on in a SIPR investigation or a disciplinary committee, if there is some difference between a finding by, and are we talking about a finding by an outside investigator? But this isn't really geared to, this is more of a DA proceeding, right? Not an IAD proceeding or even a SIPR proceeding.
For that particular
Right?
section, yes. For that
Yeah.
particular section, yes. For at least yes. Yes.
So that's really not our lane anyway. So how would we, investigate? I mean, when I think about what happened with Armstrong, that's my only point of reference is CDC, and there were findings, and 1 week before some sort of deadline, the mayor asked us to weigh in. But we didn't even have all the documents, so it was kind of an empty gesture. But this doesn't seem to speak to that kind of situation. I don't know, counsel, can you chime in on this for us, please?
I think the big notion is that would we accept there are places in the delineated lists of causes for cause that are determinations made by another bona fide entity, whether it be IAD, whether it be the courts, etc. So one is, would we accept those findings? And the commission could easily, quote unquote, easily, then just when it makes the determination for cause, it makes a determination with the acceptance of the findings by these other entities. So there's a question mark by some members of the committee, or at least one, that says, maybe not. Maybe you still want to have your own independently determined finding, not just incorporate someone else's finding. So that's one. There are, though, other elements, other delineated lists that doesn't have a finding of sort unless it's done by the commission itself. So to some extent, the commission at one point will have to have a vehicle to make a finding on some of these others that are not, that don't involve any other bona fide group making that finding. So what would we do anyway? And if our vehicle, sometimes that is done by hiring an outside investigator that is not a CIPRA, but then, you know, based on what I'm hearing from Ms. Grenage is CIPRA. So on all these others, maybe have CIPRA do those investigations. And if we're going to have CIPRA do the investigations for the others, I can see the logic of why not for everything else, even for ones that have findings done by another bona fide entity. So it's up to you whether, I mean, there still needs to be a structure mechanism for the commission to have findings on things that are not investigated by others. But if you're going to have that vehicle, would you like to use that vehicle also for findings by the city, findings by the courts, etc.? And if so, the suggestion is to consistently use CIPRA. So that's a determination you want to make. You're going to have to set up something anyway.
Okay. IG Phillips. Anything
So
to
here's
add?
my suggestion. Chair Shay, if you could go up a little bit to the top of this, maybe add right before a final sustained, maybe right before two, and just say that the commission shall determine, whether it's via policies, procedures, whatever mechanism that you guys want to call it, shall determine which investigations recommend, yeah, you can put it over there. Recommend language that says something about the commission shall determine via notification by CPRA or IAD. I know that there's a new notification mechanism. I can't remember exactly what it is. Will determine if CPRA shall initiate a parallel investigation by whatever, if it's either a majority vote or an affirmative vote of 5, however they need to. But at this point, once there's a notification mechanism, the commission is aware. CPRA will always be aware in a timely fashion. And if that means that CPRA will then communicate to the commission, you know, these are complaints that may be of concern to you all. These are all the complaints that we would have received from the from IAD or whomever regarding the chief, deputy chiefs, or however that mechanism is. So then it's a catch-all, right? You can say, okay, we've been notified. The commission will agendize this or put in whatever procedures they want, maybe delegate that to the chair and vice chair. I don't know. But I just feel like that's the easiest way, unless you want to delegate that to CPRA and have the director of CPRA make that determination. But I just think that's just the easier way to do it. And then we can hopefully move on. Thank you.
Do you think that that is just for the section that is identified here, section 2, or for all of section E?
You're talking about
The language you recommended.
well, CPRA can't do criminal investigations. Like that's not within their jurisdiction to do it. And I don't want to speak for them. I know, so I can definitely ask Director Muir to jump in here, but they can't do criminal investigations. But Director Muir, if you would like to jump in there.
I think what I'm suggesting is not whether or not CPRA would conduct criminal investigations. I know that they can't. I think what I'm suggesting is that for the commission in its discretion to determine whether or not CPRA shall investigate or conduct some sort of some sort of investigation, they investigate or bring forth evidence of cause to the commission. I know that we've had discussion around Section 4 about, what that is and what it looks like. But when I think about how you prove whether or not someone has been convicted in a court, as an example, it's not just you hear about someone getting convicted. It's not just the news reports about someone being convicted. It's about bringing to the body, the adjudicative body, the documents that show that someone was convicted, on which day, what the judgment was, what the sentence was, and what the offense was for. And that's not necessarily something that commissioners, volunteer commissioners, would have the expertise on or know how to do.
No, but
Right.
your legal counsel.
They could order certified documents in order to do so. And so I guess that's the question of whether that would be the determination for the commission to figure out whether or not CPRA shall investigate that parallel investigation or shall investigate what underlies cause. Sometimes it's a no. Sometimes it's we can get it this other way. Sometimes it's a yes. It just seems to me might be useful to just have it cover all of the sections in Section E, and then have the commission in partnership with the CPRA have a discussion about whether CPRA does investigate or conducted an investigation if they haven't already.
Question. In that case, with Cyprus not giving, I guess not having any authority to conduct criminal investigations, would they therefore contract that vote? What happens when we say that Cyprus should have the authority to investigate a parallel investigation of criminal conduct?
Director Muir?
So CIPRA can't conduct criminal investigations because the police department or the district attorney investigates crimes because that's going through that branch of government, whether you're in the judicial system and you are convicted, and if you're convicted of a crime, you have a sentence that's generally issued by a judge. For where there would ever be a parallel investigation, for example, there could be a circumstance where an officer is being criminally prosecuted, and at the same time, CPRA is investigating whether or not that officer committed a crime. And there are two different evidentiary standards. So a criminal investigation is determining, in essence, whether someone did something beyond a reasonable doubt.
Right.
And an administrative investigation is determining whether they did that by a preponderance of the evidence, which is whether it's likelier than not that they took that action. So the officers in their professional capacity are held to, I would say, a different standard than they are in their private citizen life. So if we find that it's likelier, let's say the district attorney drops a case against an officer, we might still, as an oversight entity, find that it is likelier than not that the officer committed that crime and recommend sustained findings. Does that answer your question?
Well, would that be based upon a record created by the criminal authorities, so the DA's office, and anything that we would want to do is generally told until they make their findings?
So the tolling does not prevent this entity, the CPRA, from taking continued action,
Okay.
but the evidence would be based in an administrative investigation, at least in part, on compelled statements as a part of that person's employment. So when we take a statement, most statements, when they are compelled statements, cannot be admitted into criminal court. So if there were an investigation, sure, we would request the DA's office files, for example, but and determinations related to a criminal investigation. But in conducting our own investigation, we would sit that officer down as an employee and say, you're required as a part of your employment to answer the following questions. And they will not be used against you in a criminal court, but they are being used against you in this investigative proceeding, or may be used against you in this investigative proceeding. So they're two separate tracks. So it's not a criminal investigation because it cannot lead to a criminal prosecution, but it is administrative because it can lead to the end of their employment.
Okay. So having said all of that, where are we on this? What's the recommendation?
I am, sorry, there was a question about, sorry, I brought up the question of whether having the CPRA, having the commission determine whether CPRA shall conduct an investigation into a cause finding of the chief should cover all of the sections here in E, or just as recommended by IG Phillips as to number 2. Granted, sometimes that investigation may very well just be getting certified documents from a court or finding the results of other investigations, whatever it is. But I'm wondering about that particular point. And looking to Director Muir's thoughts about that. Because it is going to be a determination. I anticipate a determination in discussion with the CPRA about what said investigation would do and whether that might be a useful, good use of your resources, whatever it may be.
Perhaps we would benefit from, not in this enumerated section, but below, noting something to the effect of when the commission or CPRA becomes aware of allegations, and I don't know what allegations, I don't necessarily think all these fit it within, but when they become aware of allegations, they shall meet to discuss whether the commission will instruct CPRA to conduct an investigation. And I don't know if that captures the spirit of what's being proposed here, but it would certainly allow for that discussion to occur. And whether it's about resources or priorities or the seriousness of the allegation.
Other thoughts?
Well, I think if you put it at the top and you just say as appropriate, that might catch it all. The language that you suggested.
And now that I think of it, apologize, Chair, but if it's just whenever any of the following categories occurs, or there's awareness of the potential cause that such a meeting is triggered, we're capturing all of these sections. And giving the commission the opportunity to say, we're aware of this conviction and we have a copy, but we were mailed a copy by the DA's office and there's no further action necessary. Or can you please, as an agency, obtain the relevant investigative documents? Or post notified us of something, can you please do follow up? Or we already have the file, can you review it, et cetera, et cetera.
Okay, so that's as appropriate. Yes, no,
I would agree with that, or whatever version Commission Council thinks is more in line with the ordinance, but makes sense to me.
council, do you have any? Do you want to opine on that? If we just add as appropriate and therefore it would apply to all of the subsections?
I was nodding greatly when you said as appropriate, because that would enable, if it's within the charter authority of SIPR to investigate, to do so, and that would give the comfort level that's needed for our community members who want SIPR to be activated.
Mr.
An ability for the commission to activate SIPR. One way or another, the commission needs to produce solid findings. So.
All right, so Jesse, what are we gonna do with this? Are you gonna highlight it and say this is what we want to add to it?
Right now, everything is in a comment, kind of having language and capturing
Okay.
discussions of where exactly it's going to go.
Okay, doke.
Not going to thumbs up my own comment.
Shall we move on?
Any other thoughts on the section discussing the chief's removal by the commission for cause?
Ms. Grenaz, you think we have aptly captured our authority as commission?
Thank you, Chair. I think this has been a useful discussion, and I think we're headed in the right direction. It's just a question of which words to use and where to put them. But I think that there is a general consensus about what needs to be included, and I will assume that between IG Phillips and Director Muir and all.
We lost you.
Yeah, I think that I think we're headed in the right direction, and I think there's a consensus that there needs to be additional language that describes the conditions upon which the commission confers with SIPRA based on the information that they have as to what is needed. So I will leave it to IG Phillips and Director Muir and the rest of you to kind of finalize the ways in which that gets expressed, what words and where it is placed in the document. Thank you.
Mhm.
I will stop throwing wrenches into this and move on.
Mm.
I know. I have a few, but we can do that in the next section. Okay. Section F, the chief's annual report. And describing what the chief's annual report needs to contain. There are some language updating it, some deletions updating and recognizing that the commission and has been hearing it chief's annual reports for a few years. There is a little bit of additional information here in section 3, which specifies in greater detail what needs to be reported of the number of investigations conducted by, completed by IAD. And then it discusses or has some updates to the timeline of the annual report. Any thoughts, comments, or suggestions about section F?
Hmm. Okay.
I'm not hearing anything, so I think we can move on. Moving on to section G and H. Well, maybe just G. Commission shall conduct an annual performance reviews and may periodically amend the criteria for department heads and the chief. There's some added language here in the middle and at the end. The part in the middle describes how new performance criteria, or really time limits when new performance criteria can be used. Essentially that before someone is held to a standard, it has to be adopted at least 11 months prior to the end of the applicable review period. And that any
Yeah.
new evaluation criteria be submitted to the city's Human Resources Department for review and input. So taking the, and then the latter part saying, nothing herein shall be construed to prohibit evaluation of IG, agency director, or the chief in closed session pursuant to applicable law. Any thoughts, comments, or questions about the changes here in G?
It's really very important that in creating these performance matrix that we do present them to the direct reports and allow them at least the 11 months they said here to perform under them, and the performance matrix should be have elements that are measurable.
There also appears to be an aspect of transparency here, which requires that said evaluation, said criteria, when amended or determined, be decided by a majority vote in open session. Thoughts, comments, questions?
I think there is an ad hoc on evaluations, and that's exactly what has to happen. The ad hoc would draft the recommended matrix and bring it to the full commission for review and vote. And it should allow some input and collaboration with the direct report in the preparation of those performance elements.
Sounds like it's well in the works.
I think you're the only one that really has had that kind of experience. The chief, we did do his performance evaluation matrix, and it was drawn a lot from his strategic plan. And but we just didn't have, he was dismissed before we had an opportunity to review his performance. But those are the steps. I have some problems there. I mean, all of these people these direct reports are also city employees, and there's a requirement even there with HR to make certain that the standards are fair and measurable, and the person is on them for at least, well, here it says 11 months, with periodic check-ins. I'm not sure I have a problem with this tweet. You were involved in the other process that didn't get off the ground. Do you have a problem with this? Tweet?
It's a commission preference. This is a decision for you to make. So there are two ways to go about it in terms of any revision, because currently it is inconsistent. The chief and the super director are placed on the same stead when it comes to the evaluation process, and the IG, it has a different section, and it's just evaluated and seen from the language differently. So,
but I understand that to be because the IG has a different purpose and has to be free of any influence and pressure with respect to what the office does or doesn't do, without the commission, I would say, quote unquote, threat of dismissal if the IG doesn't perform these tasks that may or may not be appropriate. So I understand why they put that in there for the IG to be evaluated differently.
right, and we've been noting, no matter how anyone feels about anything, that difference does cause a problem that needs to be rethought. So then there are two ways to think about how the revision would occur. One way is for the super director and the police chief. Again, they're together, IG here, to have the IG join so that all three are in the same stead, which is what is proposed here. Or to actually separate the super director so that the super director and the IG are in the same stead, and the chief is different since the chief doesn't report directly to the commission. So that there are two ways to go about the path, and it's up to you all how you want to do that.
Well, the language comes from S1 with respect to the IG, so that was intentional to make it the IG office different, be evaluated. Am I my understanding?
The municipal code has the IG position differently evaluated from the chief and the super director.
Right.
So you can either combine all three so that they're evaluated similarly from a process standpoint, or you can have it where the super director and the police chief get separated so that the super director actually gets more similarly evaluated like the IG, and the police chief is different. Recognizing that the IG and the super director report, to the commission versus the police chief does not. So it's up to you if you want to combine all three to be on the same stead, same process, or actually separate the super director.
Why separate the super director when it was supposed to be a separation of the IG?
Why don't we take IG Phillips here?
Yeah.
Thank you. I really think Commission's counsel was confusing. So the iteration where it stands right now, it was written for the IG's office to be evaluated in a way where the commission provided input and gave it to the city administrator. This was prior to the establishment and creation of S1. When S1 came about, it was made very clear that the Office of the Inspector General reported to was overseen, whatever language you want to say, by the commission.
Right.
However, the municipal code was not brought into alignment. This here would bring into alignment the Office of the Inspector General, or the IG position in and of itself, to be evaluated in the same way that the CPRA director and the chief would be evaluated. All it is bringing that into alignment. I think that is the best way to ensure that there is a fair way all the way across the board, in having the CPRA director evaluated in some different way. That means that the commission would have to come up with a different way to evaluate both the CPRA director and the OIG, given the current language in the municipal code is against the law, because there is no managerial oversight by the city administrator. Therefore, the city administrator could not evaluate the CPRA director and the IG. So my recommendation and opinion is to keep this language how it is. I think it's clear. I think it's solid. And any deviation from it would cause much more need for communication and conversation. Thank you.
And I do believe it's kind of a procedural thing that, you know, you're creating these standards and you're collaborating and talking with the direct reports about them. And that's okay. But also the municipal code, or S1, definitely wrote in a different criteria for evaluating the IG. And I don't think we can deviate from that. And I think that's what's in here. I think this follows that language. This language follows it. If I'm not mistaken.
So can I jump in really quick? I'm sorry, Mac, I see your hand up. So evaluating and separation are different, Chair Peterson. So the evaluation tool, as outlined in G, brings into alignment the Inspector General's way of being evaluated. So previously, it did not say the Inspector General needed to be noticed, right? Where previously the chief and the agency director could be noticed. So that's one thing that's bringing into alignment the way the evaluation will be utilized, or how the Inspector General will be evaluated.
That's kind of a procedural step, yeah.
Correct. So H is how the IG can be removed, because S1 says that the IG must be removed for a cause. H outlines those or enumerates what those causes are. Yeah. So these changes are two changes. G brings into alignment where the IG is being evaluated similarly to CPRA director and the chief. H is the causal reasons as to how the IG can be removed after a finding of cause is given. Does that make sense?
It makes perfect good sense. It's just
okay.
One is about procedure, one is about substance.
Correct.
We haven't gotten to H yet, but I get why we're having this discussion. Thoughts, comments, questions about section G? I don't think there are any, but section G. Okay. Section H does talk about specifically cause for removal for the IG. Chair, I know that we were working on this as an aside, outside of the larger ad hoc on our Tuesday meetings, which we still have one tomorrow. I leave it to Chair and IG if you want to discuss H now or in that small group.
No, I want to get this one clear because it caused a lot of conversation before, and I think we just need to lock this down and follow the dictates of S1, and also follow the dictates of procedural due process that includes any city employee. So you can have enumerated cause elements. I can understand that, but I don't think you can forego the procedure of notice and opportunity to serve under the performance elements and then be evaluated. And I think that's really what we're talking about. I don't have a problem with this, but maybe some others, maybe I'm missing something. I don't know why, Twee, you want to say separate the IG and put the IG's position with the SIPR position when there's a separate there are separate elements, and I don't know, one is for cause, and they delineate the cause for the IG, and we would have to find whatever causes we would want for the SIPR director. I don't know. Ms. Bernage, do you have an opinion on this?
Yeah, I just wanted to point out what is to me a very obvious distinction here, which is that the IG can be terminated for cause, whereas the SIPR director is an at-will employee. There's no need to find cause to terminate the SIPR director, whereas there is a need to find cause to terminate the IG. And that leads back to the question of how you find cause. And in this case, unlike the chief,
And unlike SIPR,
it is not appropriate for you to use SIPRA to investigate allegations that there is cause, because the IG audits SIPRA. So there's a conflict, an internal conflict of interest.
Mhm.
Therefore, you might want to include something in the ordinance that requires the commission to hire an outside party to determine cause if the commission believes there might be cause.
for the IG removal.
For the IG, exactly.
Yeah. And the reason it was written this way for a reason, to allow the IG to have the maximum amount of freedom or flexibility to exercise her duties with integrity and without pressure. Undue pressure. Where are we? Are we still stuck on this? Why? I mean, we're following the dictates of S1. And we can't change that. We have to follow it. Am I correct?
You are correct, Chair. The delineated for cause is something that had been missing, that needed to be laid out under the charter, a requirement for the city council to identify the causes. So you're correct. This is much needed and welcome for clarity.
Okay. Well, I'm not confused. Maybe I'm not seeing something that council sees, but I'm not confused about what's happening here.
I think it is a fascinating component where the logic is, if the chief is required, that the commission can only fire a chief for cause, and the commission can only fire an IG for cause, but not for the SIPR director, then why wouldn't you have the SIPR director be on the same par with the IG for evaluation, which are two different, right? The firing and for cause is very different from the evaluation process. But the logic, I understand what you're trying to say is, hey, if the SIPR director is not on the same line with the IG on for cause firing, then why would you have them on the same line when it comes to evaluation? And I only say that because
Because evaluation is something that is is really as city employees. I guess that's the only way I can look at it. They are entitled to that due process procedure of notice and an opportunity to serve under the evaluation matrix.
right. Right. The only reason why it was a possibility of one of two options, although it sounds like you and I don't know where Chair Shea is, et cetera, but if you're not interested in having separation with the with the police chief on the evaluation part, the only reason is because under the charter 604E6, it says the commission shall quote unquote periodically conduct performance review of the agency director and inspector general, period. And so this notion of maybe if the commission wishes to have a little more flexibility to evaluate maybe every 6 months versus every year, annual, et cetera, of its own direct report. So it's only within that stead to give the commission a little bit more flexibility.
But that's really, Tweety, that's in municipal government, that is the requirement that you put someone on standards, notify them of the standards, and it's recommended that you do, in fact, do reviews at the 3rd month, the 6th month, and the 9th month.
Yeah.
And so nothing about H violates that. I think you're still concerned about the super director serves at will, where the other two are for cause.
No, I'm talking about the G part where it's an annual performance evaluation now. So it's every year.
That's very common. That's commonly what happens.
And if you wish to have that, go forth.
I'm so sorry. I just wanted to jump in and note that it says nothing herein shall construe to prohibit evaluation of the inspector general, the agency director, or chief in closed session pursuant to applicable law. So if there is a question or a concern throughout our tenure, to bring us into closed session to clarify or get some conversations going regarding some issues, I don't think that there's anything that prohibits the commission from doing that. Being noticed on expectations, to Chair Peterson's point, is just industry standards. And as city employees, I think it's appropriate for the chief, the CPRA director, and the inspector general positions to also follow that guide. But I don't have any issues with this section. Director Muir, I'm not quite sure if you do, but I know our time is limited with Chair Shea, and I would like to kind of move on.
Well, I have a question. Are we empowered in making these edits to change the agency directors for at will to? I don't think we can change it from at will to for cause.
You can't.
We could.
It's in the charter.
Why? Well, the charter says that we can hire and fire, and it affirmatively says that the IG must be fired upon good cause. There's nothing that would prevent us from putting in a good cause provision in the OMC. It doesn't say specifically at will. So I guess the question that I have throughout this discussion is, why'd you make the agency director at will? And not and not the chief of police? I mean, the IG I understand, but like between the agency director and the chief of police, I think the commission's preference is civilian oversight, and so why doesn't the CPRA get the same protections as the chief of police?
Differentiation. I don't know why that was. Where does that come from? I don't know if it's.
That's E6 in the charter. It just says upon a vacancy, the agency director and IG shall be hired by the commission. By an affirmative vote of at least 5 members, the commission may terminate the agency director or the inspector general. And it goes on to say affirmatively that the commission may remove the inspector general only after adopting a finding or findings of cause. But it doesn't say so about the agency director. That feels like a conscious choice, I guess. And I guess my question to anybody who knows is why?
So where does it say that the chief, there's another section also that says the chief can only be removed for cause by the commission. So the question is, if it's silent around for cause removal of the agency director, can we write that in? Can we make it as a suggested edit at
Yes.
the time when, yeah.
Yes, because we're further limiting the power of the commission and not circumventing the intent of the charter. The charter gives us broader power, but we put broad general powers, but we put some limits or controls on it. We have the power to do so because it's not inconsistent with the charter. The charter doesn't explicitly say the agency director is at will. Again,
Okay,
the
well-
question, going back again to the question, why is the agency director at will? Was there
Mac,
a reason for it?
Mac, when you were hired and you got your hiring letter, did it say you were at will?
Yes.
Yeah, see, I'm not sure we can. I mean, we could throw it in there, but I'm not sure it'll survive.
It's within our purview to restrict ourselves.
Okay. I'm not opposed to adding that. I mean, I'm not opposed.
Director Muir?
I don't think it would be appropriate for me to comment too much on this, other than to say that if there is if that is in any way restricted, that there would need to be definitions of what a for cause termination would look like, consistent with the IGs or presumably the IGs.
But you know what?
Definitions of cause and whether or not that applied to me, I think might be a separate conversation.
Yeah.
But I think that if that decision was made, now would be the time to ensure that a definition of cause was made, which is not, we got 16 minutes left on this meeting.
So
Just saying that out loud.
with respect to the chief, are they delineated reasons, for cause reasons?
Yeah, we just went over them in section E.
Okay, so there you go. We would have to, if we're going to put that in, we would have to delineate what those reasons would be. Okay.
Do we have any information as to why the drafters of LL or S1 made the agency director at will?
I think they were mad at the first director.
Director Muir?
Mr. Sheeta?
I don't recall the reasoning, and I would suggest that if this is important information for you, that you consult with Dan Kolb, who was the principal author. I don't think that this distinction came from us meaning the community members who worked on this. But I think Dan Kolb would be able to, I think actually it was Dan Kolb who thought the SIPRA director should be at will, but I'm not remembering the reasoning behind it. So I would suggest that you contact him and he could explain it.
Okay, because the unique nature maybe of the police chief duties and unique nature of the IG's duties needed to be written in specifically, but you're right. I don't know why the agency director was left out of that particular kind of scrutiny and dismissal. So we could put a pin in that, Jess.
Director Beer, anything more?
One thing I will note is that under the city administrator, as the CPRB was turning into the CPRA, it inherited many of the formats, and the city
Okay.
administrator, agency directors are at will to the city administrator.
Yeah.
I will speculate based on my professional experience that when the new IG's position was created, as there were deliberations on that role, there was an awareness that historically, nationwide, IGs are under a unique set of political and professional pressures, and that these two considerations were made, one as an inherent sort of reflection of the previous CPRB relationship to the city administrator, and another as a unique consideration to, if we have this independent IG's office and it is truly robust, how can we prevent it from being politically swayed?
Right.
Chair, if I may also, is that obviously all the changes that are coming from the commission by this ad hoc needs to go to the full commission for a vote, and especially this one if we convert the SIPR director from an at will to a for cause environment. Obviously, we're doing that, but I just want to put a pin on that around the full commission would need to weigh in on it.
I just think it provides a little job security to the agency director as it does the IG and the chief. Why wouldn't we want to be fair?
Yeah, the for cause for the IG, it's explicitly talks about the city making that delineation. So it's very much within the city's purview.
And that distinction is important because why?
Versus the distinction of an affirmative statement by the commission that the SIPR director is also for cause, and these are the causes. Because we're limiting ourselves, so we need the full commission to weigh in on that. Versus this one, this is the city defining what the four causes are, and they have authority under the charter to do so.
And that's with the IG. Is that what you're speaking about, the IG?
Yes.
Please?
Yes.
Okay. Well, I just think that to the extent that we bring on people and we want to outline the performance that we want to see in them, and you know, there's performance-based actions to remove, and then there are misconduct actions to remove. Those are, you know, two different kinds of actions, but they are for cause. So, but that's not written maybe in the IG's list of things. For whatever reason, S1 wanted to make sure that these were the causes for the IG's removal. And I'm not seeing a reason why we need to overturn that in any way, but I can see why we would want to do something to give the same assurances to the agency director with respect to any action pertaining to removal.
There's an interesting feature that I was thinking of previously, and I think I had brought it up before, which is in recognition of the sort of the tricky situation that IGs are in, and sort of the independence that we want for them that Director Muir mentioned. The way the charter and this particular section reads, My general sense is that the city administrator could not remove the IG, and that the only way that that occurs would be through the commission. I think that makes a lot of sense in some aspects, and I think that there's good reason for that. And so I guess I'm asking us to take a look at this list, and make sure it encapsulates all the things that we care or want there, and ask if there should be more, less, or changes in some way.
Hmm.
I
So
also
we don't-
see that this particular list tends to mirror, but doesn't completely duplicate the ones that are located in the cause section for the chief, recognizing the different positions, that there generally aren't discipline investigations or misconduct investigations internally or outside of the IG, but also has an additional section, number 7, 2 consecutive annual performance evaluations, which I think actually makes a lot of sense to put into the chief section, and it's not currently there. Anyways, thoughts, comments, questions, concerns, whatever it might be, section H.
Well, we would have to convene another discussion about what would be those things that would constitute for cause for the agency director, because they aren't delineated.
I agree. I think what I would suggest is that commission council perhaps prepare or draft some language as one of a commission proposed section, and sort of draft potential language for it as part of our slate of things that we are looking into.
And in other jurisdictions, maybe the IG or an agency director may know of, there's some language similar or that addresses this element of evaluation and removal. And so we may want to reach out if there's an investigative arm of their oversight process that has some, that would reflect maybe what it is we're looking for. I don't know.
Yeah.
So there's some work to do.
I'm sorry.
So there's more work to do. If we're
There
going,
always is.
yeah,
There
if we're
always
gonna
is.
add, yeah, if we're gonna add for cause elements for the agency director, we need to do a little more research.
Agreed. I do take Ms. Grenage's point here about sort of needing to figure out a way to determine cause, and thus investigating one of these 1 through 6, really 1, 2, 4, and 5, and sort of want to think about or ask about thoughts of how a commission might trigger such an investigation to determine cause, because it shouldn't be in the CPRA.
No.
And I
That's when we
think there
would-
are provisions, well, the city administrator and can't investigate commissioners. Someone remind me, can the city administrator investigate the IG? I don't think so, right?
I certainly hope not.
Yeah,
Agreed.
Okay. So that really does beg the question of who does investigate, and whether there should be provision now rather than sort of somewhere down the line set of commissioners needs to figure out how to do it, and they don't have any direction as to how to do it.
No, they do not. And so nothing stops us from getting an outside investigator in order to accomplish this work in this paragraph.
May I say, ask if we could check in with the city? So I'm thinking like, say, for instance, the first part, if there was a discrimination or harassment claim by the IG staff, and let's say if, we do the for cause for the super director too, would the city insist on the investigation of staff employee discrimination claims, etc. So I would check. I think we should check if the city does believe it has authority for investigating.
Well, but I think we already said we wouldn't want the city.
Maybe our IG can answer that question. So it sounds like she may already know the answer.
Please.
I can only answer for the rights of the unionized employees that both CPRA and the OIG have. They have every right to file complaints against us, and they have a process that is outlined in their contract. So the question then, again, to Ms. Rashida's point, will the commission accept whatever findings those are? I don't know.
Do you know what that procedure is? Is it this within the city? Is it union? Is it outside investigator?
No, it's within the city, and there's certain investigative entities within the city that have certain jurisdictions, depending on what the allegation.
Okay. That's one aspect or feature, all right, that much like in situations involving the chief of police, the commission could take some investigation that is going on that is not specially requested or done through the city administrator, but is currently in place in other agreements. That doesn't cover everything. And the commission likely still needs some way to develop facts to generate or to determine cause nonetheless. So it's not a complete answer, but does give us some place. Ms. Grenache.
Yeah, I just feel that I need to say that given the nature of the work of an IG, I think the commission would be well served not to rely solely on any investigation done by the city, because there's all kinds of politics that figure in here. And I think that it would be not appropriate for the commission to rely on a city-driven investigation of the IG without another source of information. Most likely, you'd have to contract it out. But I do think that that's important and only fair given the nature of the work of an IG. Thank you.
Thank you. I see that we're at 8:30. Well, it's been a really good discussion about some very important structural pieces. I think it was a good discussion. I will tell you that I will miss it. So thank you all for being a part. Thank you all for having me. I think the next meeting is TBD. We will not be having a meeting on Monday, March 25th. We hope to schedule a meeting for the week of April 1st, but if that doesn't work out, the next meeting will be April 8th. Please watch your emails for probably some scheduling emails. Thank you again.
And that would go to NICA and I suspect, and this document resides somewhere where we can have access to it.
Yes, Micah got a flash drive of my entire OneDrive, which is where I saved all of my documents related to the commission. So she has every
Okay.
document that I've ever worked on, created, or produced for the commission's access. This iteration of this document is currently shared to everyone, and I will separately email it to make sure that it persists and that you all have a copy of it with all of the comments.
Thank you. Outstanding transition.
Do what I can.
Thank you.
Thank you all. Have a
Well,
good
I
night.
hope it's better not to appear before you. And that you really enjoy being wearing the black robe and dispensing justice.
I don't think I'll ever get used to that thought. We'll see. Thank you. Thank you.
Congratulations. Thank you.
Thank you. Have a good night,
Thank
everyone.
you, Jesse.
Yeah. Thank you so much. It's going to be a big hole. Big hole.
You'll be able to
Okay.
feel it. No worries.